because of various steps, my lord, like gainfully employing the youth, etc. My lord, they were misled by the secessionist forces, by the forces, my lord, outside the country, etc. And organized bandhs, which were in 2852 instances, organized bandh, call of bandh by secessionist forces.
Nil. How many?
In 18, they were 52. Now, it is nil. Now, Lord, so far as statehood is concerned, Lord, I have already made a statement before your lordships, but that apart, the statement of the Honorable Home Minister on the floor of the House, that UT is a temporary phenomenon. We are dealing with an extremely extraordinary situation. The state will have to be infused with several things so that it becomes a state, so to say. Lord, those actions, my lord, are initiated. And Lord, I may give some, my lord, instances how it is progressing, my lord, to become a state, because I am unable to give, my lord, exact.
You can wrap up in about 2 minutes now.
I'll just, my lord, give me 2 minutes. Your lordship did not write. I'll place it on record. Lord, for the purpose of ensuring that the UT becomes complete state, my lord, as it should have been like any other states, the central sector scheme investment is 28,400 crore. The investment proposals from other than central schemes is 78,000 crores. And till date, the actual investment made is 2,153 crores. Your lordship did not write. I'll write it down, then, my lord, and give it to your lordships. Lord, several initiatives have taken place, and as a result of which the transparency, Lord, has shown us that the projects have risen from, and these are all, my lord, statements on affidavit I have made, 9,229 in 2018, and now in 2023, it is 92,560. More and more people are participating in e-tendering and several e-initiatives, my lord. And therefore, my lord, that is also giving a boost. And the youth is gainfully employed. My lord, the peace doesn't come merely by police action. There are several schemes which are introduced, several beneficial projects which are introduced. I'm just giving a bird's eye view, my lord. And out of 53 projects under the Prime Minister Development Package, worth 58,477 crores, out of 53, 32 are completed. This is how progressively, my lord, we are proceeding to make it a complete state. But I am unable to give, my lord, my instructions are the exact time period right now about the complete statehood, while saying that union territory status is a temporary status because of the peculiar circumstances the state had passed through with repeated and consistent disturbances of decades. It might take some time, and we have shown, my lord, the progress also. Very, Lord, it was heartening for me also to note that only in 2022, January 22 to December 22, 1.88 crores tourists visited. The lordships are aware, the main industry so far was tourism in Jammu and Kashmir. Now, my lord, industries are coming. And till date in 2023, 1 crore tourists. It gives employment, it generates employment in various sectors. My lord, one, there is a tourism boom. So these are the steps which are being taken by the central government, which can be taken only if there is a union territory. And I have shown the Reorganization Act. It is having all trappings of the state. But the election, the government is ready. It is for the Election Commission of India and Election Commission of the state to take the call. Out of 3, which election to take place first and how. The updating of the voters list is complete. Some part is missing, but it is yet to be over. It's in the process. It would be over, my lord, in a month or so, my lord. That's what I'm told. Thereafter, my lord, they will take a call considering the overall situation.
You'll be wondering what the Chief Justice is doing is on a phone from the court.
Yes. This is my learning assistant.
But I just want to know whether your lordships are taking into account these facts, because whether that's extremely relevant from our point of view. Because if your lordships had said earlier that subsequent facts will not be taken into account, we are dealing with the law, we are dealing with these facts.
Mr. Sibal, these facts on what they have said would have possibly no bearing on the constitutional issue which has been argued.
But even otherwise, because we have to counter those facts, Mullah.
We had asked them a question on the roadmap for holding an election.
That's fine, Mullah.
That's what they have responded.
But Mullah,
That's not, Mullah, in my argument was met.
But our decision on the constitutional issue has to be on constitutional.
but Mullah, these facts will go into the mind of the court because they are trying to show as to how this enormous change has taken place for the benefit of the people of Jammu and Kashmir. If you have 5,000 people under house arrest and 144 throughout the state, there can be no bun. So, let's not, my request to your lordships is, please don't enter into this arena, because we will have to counter it with all kinds of facts, which I don't think is necessary for this court.
The nature of the development work which the government says has taken place post August 2019, this may not be of relevance to your constitutional challenge. And therefore, when they respond to the constitutional challenge, that has to be dealt with independent.
I didn't rely upon it while
But
answering on
these
merit.
facts, if they come into your lordship's part of the record, then that has.
I think, Mr. Sibal, what the solicitor, to be fair to the solicitor, what the solicitor was saying is that the roadmap to full statehood would take a little time.
That's obvious.
Right now, that they are the development. There, his submission is that right now development work is taking place. Some stability has to be brought about. This is not a permanent arrangement, namely the UT status. They envisage that it will be a movement from UT to statehood again. We can't give you a fixed point of time when we will restore statehood, but they have told us the process which they are following on the path to.
I have no objection.
That,
that statement, I have no objection.
And that's how we read it.
Yes,
actually.
but if any other fact that you bring to your lordship's notice has no bearing, because I'll have to counter.
Mr. Solicitor, Mr. Attorney, we take it that what you said, Solicitor, a short while back, is along the lines what we said.
Yes, yes.
That this is
Answer the election and
the roadmap to
statehood
full-
query, not as a
Correct. I have
justification
no
for.
problems to that.
And Mr. Sibal also fairly says that he has no difficulty about that.
But
During my
he says
arguments
that
on merits,
this
I
is
never
happened.
relied upon.
This cannot be an answer to the constitutional challenge.
But even otherwise, it should
I
not
also,
be
Malad,
into your
didn't,
lordship's
uh,
mind,
I-
Malad, that these are great things that are happening, Malad, because today the kind of drugs that are happening with the youth in Jammu, Kashmir is unbelievable. But I don't want to enter into that controversy.
Can I put it like this?
The unemployment rate is enormous.
Mr. Sibal, these are matters on which there can be and should be in a democracy policy differences,
That's right.
but that can't affect the constitutional
Absolutely.
answer to a constitutional
Therefore,
challenge.
once you start placing these facts and Malad, your lordship.
But therefore, we place those facts which he mentioned in the perspective of the roadmap to statehood. That's all, and nothing on.
This is
on
not
the,
a justification.
this is not a justification. It just cannot be, from our perspective, also to the answer to the constitutional challenge. We'll have to address the constitutional
So your
challenge. on
lordship will
constitutional
allow me
grounds.
to face some counter facts to that?
May
No,
I
it's
put
not
it like this?
necessary,
Sibal,
Mr.
I had intervened that stage also when
Yeah.
you were saying, only for this reason that we wanted in a conspectus to understand when they look to a restoration of statehood.
No
To
problem.
which they made a statement that
That's no issue, Malad. They say that will take some time. Your lordships will decide on that issue, Malad.
Decide
That's
what it is
confined to
about.
our answer, our question to Mr.
But we
Solicitor.
are, Band
are
level
very clear
reduced
on
to
this.
zero, band
Neither-
level reduced to
but
zero, all
it's
that,
not
much.
right.
With respect, I say your lordship should not even, those facts are not relevant for the purposes of your lordship's decision is all that I
And
say.
therefore, we had not taken that additional
Right.
affidavit which was sought to be filed at the inception of the record. And I don't think there's been any change in that.
Thank you.
position.
I think it's better understood like this. Neither these statements nor their refutation, if need be, will enter into the question of determining the constitutional validity.
Correct.
So therefore, paraphrase it like that.
Yeah.
We don't want to put it like
And
that.
on that
Fine,
aspect,
I also
on
didn't
that,
rely.
on that,
Fine,
Mr.
Mr.
Sibal, Mr.
It's for an
Attorney and
entirely
Mr.
different
Solicitor,
purpose.
I think there's a broad-based understanding on both sides that the constitutional challenge has to be answered on.
But
During my assistance on merits, I never relied upon
The
this.
problem is the following, these are televised, all this is being televised and all of this being recorded. So Malad, these facts come on the record, they are part of the public space and people feel what a great thing has been done by the government. Malad, this creates a problem. Malad, that's why I.
What's why progress never creates problem.
I'm sorry.
Lack
please
of
allow me.
Offenses
All right,
do
Mr.
not.
Sibal, we get
allow
your
me.
point. We got your point. I think we have clarified it,
Yes.
that the constitutional challenge will be dealt with by the Supreme Court on constitutional grounds.
That's right. None of this should Malad enter into the.
And they have not argued equity in defense to your constitutional
That's all,
challenge.
that's all, Malad, that's all.
Yes.
I suppose these statements are otherwise in the public domain. In elections,
There's a
will
lot
be-
in the public
Mr.
domain.
And therefore,
Mr. Attorney,
Certainly,
public
there's a
will
lot.
consume it.
Mr. Attorney General, you're meeting the constitutional challenge on constitutional argument.
Which I
We
did,
must
but I never-
address this matter like any other constitutional
That's
matter as a
right, that's right. In the
constitutional issue
public
which we have to
I can
confront.
raise a lot of facts.
But when I answer the question of election and the statehood, these figures will go into our
So
decision.
that you made, that's not part of the public space.
And that
You-
Mr.
because you
Sibal has
need-
also clarified, there can't be any.
That's internal.
We needn't labor this issue. We are all now clear
Yes, yes.
on conceptual grounds. Mr. Attorney, now we'll hear you.
Please, Your Lordship. And one is reminded of Dworkin's very deep engagement on the hard cases and not one single.
Only
Yes, yes,
one
yes.
interruption, Murad, on the lighter side. My learned friend said that there are some people who are under house arrest and therefore there is no bond. But that means the right people are in the house arrest.
5,000 people. Let's not make
Isn't
a,
it that?
let's make a mockery of democracy.
People are under house arrest.
5,000 people were under house arrest at that time. 144 was throughout the state. This court, Manadina judgment has recognized that. Well, the internet was shut down and then they are saying there were no bunds. Why? How can there be bunds when people can't even go to hospital? People could not go to hospital because of the bunds. They died.
I wish,
A single.
Let's not go into all
I,
this.
Mr.
I
Sibal,
wish we don't enter into
one
this
second.
dialogue.
Mr. Attorney,
I,
Mr. Sibal, we have, right from the inception of the hearing, we have heard this matter in a sense of dispassionateness,
absolutely.
the sense of objectivity which must govern an answer to a constitutional challenge. We request both sides. Let's maintain it at that level.
Absolutely.
Because, yes. Yes,
I don't
Mr.
think
Attorney.
neither the solicitor nor me has entered into the domain to try to color the mind of the judges. We've not done that.
All right. Yes, Mr. Attorney.
So as I say that the famous principle versus rules and the hard cases thesis to Dworkin, one wonders we are not in a situation like this. We're leaving, taking off from what where I left day for yesterday. There's a couple of digressions I would like to probably play before a lot before I. Because when you talk about the intent of a law, Wittgenstein, who co-authored with Bertrand Russell, and his famous philosophical investigation, he talks about a signpost. How do we know what a signpost means? There must be a practice of using the signpost and an understanding we develop over the using of the signpost. Without that practice and understanding, the signpost means nothing. So this principle has been used in various circumstances to bring closer. If there is an understanding about a law on the basis of a practice, then interpretation follows one course, one trajectory. But if there is a lack of understanding or conflict of understanding, interpretation heads in another trajectory. Therefore, we are trying to understand the intent and connect with the content of Article 370. You have to keep in mind what went into the original author's making of 370 and what has happened over a period of time by the practice of using Article 370. So a text sometimes, by reason of its aging and the use of the text, may demonstrate a certain practice which may show in a slightly different direction. That's why in the context of destitute, two important principles come. A disuse plus a contrary practice. I don't get into the destitute doctrine, it's not necessary for a purpose. I don't want to flag that. So when you're trying to understand 370 in a perspective, we have all these complexities. It's not really a case of reading the text, looking at the text and the context and arriving at a meaning. We are confounded by the practice of Article 370, whether in conformity with the original intent or in deviation from it. So the court is now called upon to look at the age of the text and the use of the text and how in current times the president understands both the original text and the use of the text, and the president now understands this is what I would like to do with the text. So I left day for yesterday on this proposition when the president is not precluded for what I call the taking stock of what Article 370 has done over a period of time. This taking stock is written into Article 370. So while we do that, how the president may take stock and how the court will be called upon to have a glimpse of understanding of what the president intended to do by taking stock. I just want to place 5, 6 propositions in the context of construction against absurdity. These are all gathered from books on interpretation of statutes. So the presumption against absurdity will, number one, avoid an impossible result.
Presumption.
It will also avoid an unworkable or impracticable result. I'll put them all together and hand it to your lordships now. And it will also avoid an anomalous or illogical result. And connected to that is to avoid a futile or a pointless result.
What is the third one you said, Mr. Attorney?
First one is
No,
the doctrine of impossible, the contracted is different. But when it comes to textual impossibility or constitutional text, it may stand on a different footing. That's why all these principles have a certain importance in construing Article 370. So I referred briefly the other day about this presidential poll, lordships. In 1970, the 140 it's not
Yes.
so we are trying to look at the proviso to clause 3 about
So which is the part of this judgment you want us to see? Para?
I'll give the paragraphs, your lordships.
You have it opened up and you have it on the screen.
Yeah,
as well, sir.
we have paragraphs. I'll just summarize the proposition. Was the presidential election had to be held. Gujarat Assembly was dissolved. Therefore, the electoral college was incomplete. So the argument was, without the electoral college becoming complete, you can't hold a presidential election. Court said they read Articles 55, 54, etc., and come to a conclusion. It's a mandate that you must hold the election before the president term expires. Therefore, the lack of the electoral college not being complete will not come in the way. So that unless you fulfill that impossible, that the court says you must, the argument was, you must have the electoral college completed before you hold the elections. Therefore, the
So
mandate
you're
of holding the
trying
election.
You're stretching that to our case because According to you, the conditions for the application of the proviso to Article 373 are absent, and therefore the substantive part cannot be rendered into disuse merely
That's
because
what
of the
you're
absence of the
absolutely
Constituent
right.
Assembly.
Therefore, I come to the arguments on the other side currently. Now, there is no principle in
What's the para?
jurisprudence.
Just give us a small para, so we are then done with this judgment.
These paragraphs 5, 4, 5, 12, 13, 15, 20, 21, 29, and 47. So there they look at the impossibility of performance.
How
So
do
what
they,
I'm trying-
how do they formulate it? Just let's see it in a moment.
I'll presently come to it.
It's 7 judges, so we can just look at maybe that one or two sentences and how they formulate it.
Give me paragraph. Let's see paragraph 4 is. Paragraph 4 at page 47 of the running page 47 of the judgment. So they come to a conclusion that the conclusion part of paragraph 4, it shows that the time to hold an election to fill a vacancy is also mandatory in character. Then paragraph 15, that's it.
Some of this suggest. So let's take it to
Page 49, running page 49 of the judgment, paragraph 14, last sentence, and then thereafter paragraph 15. Paragraph 14, the last sentence. Sentence beginning, the necessity. No, Justice Scholars got that paragraph.
Only 26 pages.
stop you from. Strike all that.
Paragraph 14, last
49.
sentence.
Page 49.
The sentence beginning the necessity for completing the election.
14.
Yes.
Before the expiration, the term is enjoined by the Constitution, public and state interests, and to see that the governance of the country is not paralyzed by non-compliance with the provision that there shall be a President of India. Next paragraph. The impossibility of the completion of the election to fill the vacancy in the office of the President before the expiration of the term to office in the case of so-and-so, as may appear from Section 7 of the 1952 Act, does not rob Article 62(1) of its mandatory character. The maxim of law impotentiae excusa legem is intimately connected with another maxim of law, lex non cogita impossibilia. Impotentiae excusa legem is that when there is a necessity or invincible disability to perform the mandatory part of the law, that impotentiae excuses. The law does not compel one to do that which one cannot possibly perform. So I cannot possibly resurrect the Constituent Assembly and say, I want your opinion on this matter. So therefore, when it appears that the performance of the formalities prescribed by a statute has been rendered impossible by circumstances over which the persons interested has no control, like the act of God, circumstance will be taken as a valid excuse, so and so, etc. So it has two aspects. One, you are relieved from performance. You are also relieved from performance the way it commands you to perform.
Yes.
29. Paragraph 21. And an argument that it shall not be done is available in paragraph 21. Your Lordship, of paragraph 21. The interveners submitted that the units of the Electoral College were House of Parliament and the Legislative Assembly of the state. Johnson submitted that the democratic character of the Constitution demanded that there should be elected members of the Legislative Assembly of the states to be entitled to cast votes at election. It was said that states were denied the right, they would be denied representation. It was also said that if the states were denied the right to cast votes in election, the parity between the states and the union would be disturbed. All that argument is considered. And kindly turn to paragraph 29. Again. It was said by the interveners that Article 54 reflects the democratic patterns of participation by the states in the choice of the president, and if a state were denied such a right, it would be undemocratic. Recourse was taken to Article 368 to show that Articles 54 and 55 are mentioned in the proviso to Article 368. And if any amendment of Articles 54 and 55 is required, consent of the states is necessary. It therefore said by the intervener in Articles 54 and 55, read with 368 would be a key to the interpretation of Article 62 that no election of the president could be held without the representation of the elected members of the Legislative Assembly of the state where the assembly has been dissolved. These submissions on behalf of the intervener are without substance. Then we go to paragraph 47, the conclusion. Can you also make a note of paragraph 33? If as a result of dissolution of a legislative assembly of a state, there are no elected members of a legislative assembly of a state will not have been elected member of the state legislative assembly to qualify for the electoral college. It may be said in the analogy of the observations in the Karake Supra There are vacancies in the electoral college by reason of the fact that there are no elected members of the Legislative Assembly of the state where the Legislative Assembly is dissolved. That matter will not be a ground either for preventing the holding of the election on the expiry of the term of the president or suggesting the election to fill the vacancy caused by the expiry of the term for the office of the president could be held only after the election Legislative Assembly of the state or the Legislative Assembly is held. So for the proposition, and then kindly paragraph 47, the conclusion is drawn. Paragraph 47 is the page 57, landing page 57 of judgment.
Yes, yes, Mr. Attorney General, we've seen that.
Therefore, we are trying to find out if falling back on the proviso is an impediment. Therefore, the president is deprived of the authority under clause 3 to go either way. Will that not do violence to the text and the intent of Article 370? So one principle in law is very clear that no text once enacted will efface itself out. We only know the principle of express or implied repeal. So there's nothing like, I have done my duty, therefore I exit the scene. Clause 3 still remains as an important part of reaching the exit stage. The only question is, how do you reach it? What is the more thorough way of reaching that exit stage? What consideration will weigh the president in exercising the power under clause 3? So one possibility is, maybe it's extreme, to say that because the Constituent Assembly is no longer exists, the proviso dissolves itself along with the Assembly. That's one way of looking at it. Suppose we don't want to go that route. Then the president could have said, I am free to exercise my power under clause 3 to bring to a close all of Article 370, subject to whatever other considerations the president may take into account. The other way is, should I try to follow a precedent set by the president earlier by recourse to Article 367 and recourse to Article 371D? So extending any provision of the Constitution with modification and find out if I can possibly take the assistance of any body who can fit in within the framework of the Constituent Assembly. So in 2 occasions, the president has done that earlier. I'll come to those details. So there are a large number of provisions in the Constitution, which Dhawan also tried to point out, non-legislative functions of the legislature. You pass a resolution, you pass recommendations. These are non-legislative functions. Recommendation power, a role assigned to the Constituent Assembly, was a non-legislative function. It is not a legislative function at all. Is the reference. Yes. Video page. And then we have a key in Article 356, 1B, where after a presidential proclamation, the president can declare that the powers of the legislature. It doesn't say the legislative function. So he talks about a compendium of powers available to the legislature, and that the president takes over to hand over to the parliament. Therefore, the sequence of events which was contemplated in a situation like this, where there is a void, there is an impossibility of complying with the proviso to clause 3. And how do I fill that void, if at all it's a void? I said the president could have said, without recourse to any other course of action, I could have myself taken decision on rendering Article 370 inoperative subject to modifications. But the president does not adopt that course. She wants to be guided by a process which will closely be approximating to the non-legislative functions of a constituent assembly. That is where the legislative assembly substitution comes in. And once it is the non-legislative power of the legislative assembly, under 356(1)(b), the parliament can certainly say, I take stock of what I can do. And the parliament recommends to the president, which then we see at CO 273. So therefore, there's a sequence in which president addresses, having regard to the magnitude of the problem, the importance of the solution to be arrived at, and the difficulties in handling these momentous issues facing the nation and J&K for a long period. So all these imponderables enter into the decision-making process by the president. Therefore, if a particular process is sought to be the best process, in order that any legal objection could be taken against that, is not taken. You may still find a hole in that. That's a different matter. That's how the sequence of events have taken place. So I don't find, therefore, if the doctrine of impossibility stars one on the face, you are not paralyzed. So clause, since Article 370, the author, sometimes I wonder poor Gopal Samayanga, we keep talking about his statements in the Constituent Assembly. We have traveled far beyond what he thought was happening. Therefore, if we think that clause 3 of Article 370 was undergoing a natural death, I don't find any room for that to happen at all. So what happens today is, because of the age of the text, the long duration by which Article 370 has been used, rightly or wrongly, we have counsel for the petition saying we are reasonable authors of the text of Article 370. So on the one hand, the original author, the original intent, and its practice over a period of time, which can be given a certain understanding in construction. On the other side, we are the reasonable authors of what we'll say about Article 370. But two schools of thought there. One which says 2 and 3 will efface itself out. The other says the whole of Article 370 will go, because after 1957, it can't serve any purpose. So this conundrum of two reasonable authors entering into a construction as against the intent of Article 370 and its practice to be considered on an objective basis, having regard to the purpose which Article 370 was sought to be invoked at that point of time. So all that will enter into the construction of Article 370. So that's why I say the president is not precluded from taking stock of all this. It's not really writing on a clean slate now. I mean, one has to take stock of what will happen over a period of time. You may have so many choice of action. You may have called upon to comply with certain mandatory requirements under the Constitution. You may have taken the Article 3 review of the legislature. Very important mandatory requirements in ordinary times. But when certain other compelling circumstances which confronted the nation for a long period, the parliament, the president. So therefore, all those variables which enter into taking a final view on Article 370 has been taken in this manner. That's why I started saying about Lincoln, I quote from an entirely different perspective. It's not about end justifying the means. It's about taking stock of a very complex situation. Do we have a mathematical formula to do it? Or do we only measure it by saying there are constitutional mandates? If you disobey them, you breach them, then you can't follow any portion as regards Article 370? Or look at the future of J&K. I do not know whether these questions can be answered on any normative mathematical position through a judicial scrutiny and then weighed on various fine golden scales. Very difficult. So when Keshavananda Bharati has told us now, look here, don't breach fundamental features of the Constitution. Now it's become an integral part of our understanding of the Constitution. Therefore, we are told to go forward, say how the salient features of the Constitution and its functioning and exercise do not permit any deviations. Fair enough. But you look at the entire Part 18 of the Constitution, 352 onwards. And 352 occupies a very important place in the constellation of Part 18. External aggression, internal disturbance. So how do we have a mathematical yardstick or a criteria to say, this is how you will do it in the context of external aggression. This is how you will do it in the context of internal disturbance. You will have some fair, broad standards where fundamental values are not breached. But if there is something which you have to negotiate, even with the breach of some fundamental values, what do you do? Is it a political question or is it a pure judicial question to be answered in the basis of textual reading of the Constitution? Well, that's what is confronting the court. But we are trying to assist the court in saying that you come as close as possible certain meanings which will advance the course of justice and understanding the scheme of Article 370. So this maxim, impotentia excusat legum, has been applied in large number of circumstances in the field of contracts, in the field of legislations, so on and so forth. I'll give a few illustrations later. Then we take your lordships to go beyond this judgment. Take me to submission. P70. A few minutes. We have a mass of
What else? What more now, Mr. Attorney?
I may request Lordships to come to my written submissions and that's volume 4. Just want to place a few comments at this point of time.
What would be the PDF page?
Yeah. Volume 4. There's a separate volume.
Yes.
Internal
What
submission.
page? You
Yes,
read up to the
page,
point, so.
PDF page 26. Couple of paragraphs from the submissions. I just want to make a small
Page 26.
observation that in the context of what I was trying to communicate to the court, one looks at all those statements from Keshavananda onwards, for my in the 1977 resolution case. The justiciability of the decision-making process. President or no president does not make a difference. If the justiciability will enter in the decision-making process. They were all cases of dissolutions of assemblies. A very,
Referring to
very
the-
narrow question of a resolution of an assembly. But we are went on a larger canvas. Lordship, please,
You're
sorry.
referring to the standstill agreement or something, so that is what page 26 is about.
Which is the para that you're referring to, Mr. Attorney?
Yes.
Because page 26, we have, the standstill agreement, as Justice Call said.
Your page 26. I think it should be page 27. It begins at page 27. PDF page 27.
Idea of Article 370, its relevance and scope.
That's right, that's right.
Let's read through it. Let's see. Yes, we got
PDF
it.
page 27. So before I try to convey this, that you try to invoke the jurisprudence of Bommai in a context like this, that could be a problem. As I said, there is a context of a resolution of an assembly. What factors go into it, whether they are relevant, objectively scrutinizable or not. But we are, as I said, in a larger canvas of taking a decision which has not only an importance for the purpose of looking at a part of the constitution to serve a certain purpose over a period of time, but looking at the future. So in all those cases, you're looking at an event which had a limited impact at a given point of time. We are looking at events which will have far-reaching importance forever in the future. Therefore, anything which is said in Bommai as conclusive in regard to judicial review, sovereignty, etc., I think may not be opposite. Let me not be taken to be understood that merely because there is too many complexities involved, the importance of the decision to be taken, and the impossibility dimension, etc., certain fundamental mandatory requirements of the Constitution can be slighted. I'm not proposing that at all. But we are trying to find out if, without slighting them, if there is a way that has been adopted, or if it's not been fundamentally breached, irreversibly breached. I'll come to that argument a little later. Therefore, the court will look at it very differently. So let me try to read a few paragraphs of my submission here in 370. I have been trying to say this, that in paragraph 3, Article 370 envisaged a scheme of constitutional integration of the state of J&K with the Union of India, and thereby establish an interim system for the governance and administration of the state of J&K unit. A complete integration was achieved as was done in respect of other states. That's why much labor was taken by learned solicitor to tell your lordships. Look at the long history of what happened in the rest of the country. We all went through, many of them went through the process of constitutional ideas, constituent assemblies, a draft constitution, then comes Bierendorf's committee on a model constitution. So all that has been gone through in the rest of the country. So it is nothing new which has happened here. Only thing is having regard to the situation obtaining then the external issues. The parliament thought, let us tide over it. How do you tide over it? We need a mechanism to tide over it. And we also probably inject into it a constitutional integration thought. That constitutional integration thought as the three aspects of 370, as I told you Lordship yesterday, that I have set out in paragraph in the running sequence. Judgment to show that the president, the exercise of power of the president is legislative and not executive. The governor's powers under the 5th schedule, powers under the 6th schedule to extend a parliamentary law to the 5th schedule area has been said to be a legislative exercise. So modification has been considered with several judgments to say it's a very wide amplitude. It's as good as sitting in judgment over the parliamentary legislation or the constitution. President is given that power to extend the constitutional provision with modifications, with that supreme authority given to the president. Yesterday I pointed out at page PDF page 33, That's part of Chevrolu's judgment. And the middle of that paragraph, where it says, Your Lordships have that page of my. The one sentence, application for forms of it. That's right. That's right. I just want to. Then let me take Your Lordships to few aspects of the recommendation. It's only to throw some light on that. Paragraph 12 at page 36. You can pick up any dictionary or any precedent on this question of nature of recommendation. The larger number of provisions in the Constitution of India which uses the word expression recommendation. The context would be important. Sometimes it's a recommendation which can't be simply ignored or disregarded. Sometimes it can be binding. But by and large, the recommendation concept is to advise, to commend for action. All that few illustrations I have set out here in paragraph 12, I don't trouble Your Lordships with reading. I just only conclude this part of the argument by inviting a lot of attention to paragraph 18 of the submission, that page, internal page 38. Either the legislature of the state nor any resident of the state has any independent right in the continued retention of Article 370. In other words, beyond the constitutional integration process, the visualized to be completed, there was no other purpose of Article 370. As such, no person could have claimed the right of permanent retention of Article 370 as a permanent integration process. And the concluding observations are in paragraph 21, begins at page 39 and ends at page 40. And the last few sentences here, running to this page number 40 of the PDF. And that's right.
Let's read your conclusion, Mr.
That's right.
Atkinson, how you sort of sum it up.
Therefore, we are told that Article 370, by reason of its exercise over a period of time, she is now open to several interpretations. And there's only one solitary interpretation, that it is to aid the constitutional integration process. Whatever has happened even thereafter will have to be seen in the light of that. If anything has, by way of deviation occurred, well, it is open to correction by the president. So that's precisely what's happened now. The president says, I started saying, the president is not precluded from taking stock. The taking stock is inherent in Article 370. So if there is anything intrinsically which forbids the president to take stock of Article 370 and its exercise over a period of time, then one can understand it. But I don't think anything is available there. So therefore, I think it will open to the president to take stock of all the exercise undertaken under Article 370 and take into account the larger considerations which loom large before the nation, particularly the state of Indian case.
Yes, Mr. Anything else, Mr. Attorney? Now?
Your Worship. So we are confronted with just a- shifted the page. This part of it. Page. I'm sorry, navigating the system.
We are also navigating the time constraints, Mr. Attorney, now. So I think we can wrap up now, Mr. Attorney. If something remains, you can tell us after lunch if there's some thought which escaped your mind or something.
I would have done it very briefly now.
Yes.
I had a. Shared with the court.
There's some document I wanted to share with the court. I think it's missed getting into the court system.
Mr. Attorney, why don't we do this? We'll call upon the next counsel. You can come back to us after lunch if you're junior and you can
I
find it
do
at
that.
lunch. We'll give you 2 minutes. There's no difficulty. So there's some important thought that you have missed. We'll certainly not stand on the formality. You have concluded the argument. We'll let you again. So if there's something which remains, you can tell us in a minute after lunch, Mr. Attorney General.
Very well.
Thank you, Mr. Attorney. Mr. Sarve will be arguing
Yes.
after this. Yes,
may I
Mr.
have
Sarve.
Short submission, man.
To make, before I come back on that. In my I thought we wanted to share a 2-page note with your lordship, but I think it didn't get into the system. Let me do it.
There's some thought which remains. You can come back after lunch. No difficulty.
Very well.
Thank you, Mr. Attorney
Very
General.
well.
Thank you. Yes, Mr. Sarve.
Yes.
I have a few, okay, then I'll come back after.
Yes,
after
certainly.
lunch.
There's something, a point here or there which has been missed out. You can
Yes,
tell us.
I'll
We'll add
continue
it.
that
We'll add it.
There are a few observations I want to make on certain aspects. So can I continue thereafter? Yes.
Yes, yes, Mr. Sarve.
Yes. My lord, I don't want, your lordship has heard this matter on both sides at considerable length. And the solicitor has, in great detail and with his customary meticulousness, ticked all the boxes and covered all the points from our point of view.
Appearing for in this matter, for the sake of the record, we must make a.
Yes, I'm appearing on behalf of the applicant in IA 9573 of 2020 in petition 1099 of 2019. I have, my lord, for your lordship's convenience, made a 3-page roadmap of what I'm going to submit, if your lordships permit me to hand it over, so that it will be easier just instead of your lordship noting down.
Yes, Mr. Sarve.
Yes.
Has it been given to the courtmaster already?
I believe so, my lord. Mr. Agarwal from. It has been sent, I believe.
We'll just display it for everybody because that way the other side also knows what your argument
Yes.
is. So therefore we take it as just an aid memo, nothing more.
It's like a skeleton of submission.
All right.
It's just It just sets out the points which I'm going to address, not what I'm going to say.
Just give us a moment, it will be uploaded so that
Yeah,
that way
not please.
your learned friends on the other side also simultaneously
course.
can see what we have. So Shankar, you can tell Mr. Dhawan and Mr. Jha. They'll get it on the main screen as well. But I'm sure the main screen will also have it for. Okay, George.
No, without interrupting my learned friend, I just want to, there's some part which is missing in our, I'll try to upload it to the, I can share with the lordships. Right.
Yes, Mr. Sarvesh?
Yes. But I'm only to, as my note said, I'm only supplementing some of the submissions which have been made already. And I've just picked up the issues. One is the construction of the proviso to sub-article 3 of 370. The attorney has addressed your lordship at length. Only a few points to add to what he has said. The width of power under Article 370, because that has been the subject matter of some discussion. The nature of the power exercised by President under various sub-articles of Article 370, I don't think, there was a suggestion made that this might be executive in nature. The absence of a challenge on administrative law principle of abuse of power, it's necessary to get a few concepts in their right perspective. The exclusion of judicial review beyond the question of competence, questions that are political in nature. And the use of power under 356 to make changes that may be irreversible. And finally, the violation of basic structure. Very short submission in each of these headings. The first point relates to the construction of the proviso. Your lordship have heard detailed submissions by the solicitor and by the attorney. And my lord, I just want to put it in a frame. So normally, these are the three aspects which one would look at: the textual, the contextual, and the historical. We have and the solicitor read it out to your also. The author of the provision and the list of dates given by the solicitor sets out in detail the confabulations, including differences of opinion on whether there should at all be a special treatment of Kashmir. Then Gopal Swami Iyengar's draft, its brief discussion, and its adoption by the Constituent Assembly. And one thing was clear: this was an element accommodating certain compromises, political compromises within the constitutional framework. Your Lordship has read all of that. I'm not going to repeat reading any of that. But that has been sufficiently put across. And it now stands as it does. And its words have to be given their plain meaning. So, my Lord, the first thing Your Lordship would do in my respectful submission is the textual bit. Now, in the textual bit, what is of great significance in this point has been put. If the idea was that the president could act only to give effect to a recommendation of the Constituent Assembly, then that would have been made the precondition for exercise of power. Perhaps the article would have said, if a recommendation is received from the Constituent Assembly, then the president may. And Your Lord, in fact, in the course of the hearing, my Lord, the Chief Justice gave the example of certain other articles where it says, if a reference is made or if something is done, then. But that's not the frame in which this was drawn up. One of the articles, my Lord, of that kind is 249. Courts are very well familiar with that. It starts by saying, if the Council of States has declared by resolution, then it shall be lawful to make laws. So that is a
Shall be necessary.
yes. So, my Lord, shall be necessary here must then be subject to the principle that if there is a Constituent Assembly, then it's first of all, the word is recommendation, not concurrence. And secondly, that becomes necessary because if there is a Constituent Assembly, then you cannot act in vacuum. That was, in my respectful submission, the textually, because my Lord, we must first of all discern legislative intent out of language. And from the language, when the Constitution knows, or the drafting of the Constitution, the authors of the Constitution knew that there were certain models in which it says, if something is done, then you may exercise a power. Is the president to act, my Lord, only to give effect to the desire of the Constituent Assembly, or is he to receive a recommendation from the Constituent Assembly? And obviously, the compromise was he must receive a recommendation from the Constituent Assembly, which obviously means if there is one, he must. Concurrence, obviously, because concurrence, then your power gets hedged in. And this is all textual.
Except the area which was covered in instrument of accession.
Yes, ma'am.
The exercise of the power under the proviso to clause 3 brings about a complete abrogation of status,
Correct, ma'am.
abrogation of 370.
Yes.
In which case, all the limitations which are even introduced by the earlier provisions of clause of Article 370 are lifted.
Yes.
Including the concurrence on the distribution of legislative
Yes, ma'am.
power,
Yes.
consultation.
Yes.
Now, could it have been the intent that you require the concurrence for altering the distribution of legislative power or for altering any other provision of the Constitution, but for abrogating the article itself, nothing more than a mere recommendation is required?
Which, my lord, drops me, I'm deeply obliged, my lord, which brings me to the second, the contextual.
Power under the proviso is exercised,
Yes.
then there is no limitation at all.
Absolutely. And that, my lord, brings me to B, the contextual. And in fact, that was the direct intent. And your lordship will see it from another point of view. There's another point of view. Till the arrangement is in place, unlike other states, where the constitution sets out legislative powers in the 7th schedule in absolute terms. And you need a very elaborate mechanism to tinker with those 7th schedule. It has to be with 50% states voting, etc. Your lordship knows the difference. Here, there was a political agreement and the whole circumstances, including, as Mr. Anger spells out, the specter of the United Nations, which today is, of course, irrelevant, but at that time was very relevant. The problems in the state. So there was a agreement which is embodied in B, which has concurrence. But if this led to a situation which ultimately prevented the purpose of 370, the purpose of 370 was not to create a permanent divide in the constitution. There are lots of material has been shown to you. It was a phased integration. I'm going to deal, Dr. Dhawan has raised a very interesting point of asymmetric federalism, whether that became part of the basic structure. I'm going to deal separately. But the historical material available to a court, and we have, unlike certain other courts, we have always looked at historical material, especially for articles like this. There was a safety valve in sub-article 3. That if the political compromise in sub-article 1 fails to achieve the purpose, at any time it might become necessary to pull the plug. And sub-article 3 is that plug. Now, if one looks at it that way, the whole thing falls in place. The framers of the Constitution kept with the President the power to do away with this special arrangement.
Yes.
And history, my lord, bears testimony to the foresight and wisdom of those, my lord, despite the criticism at that time and the political debate which must, in a democracy, you must always have the noise of a democracy, Mr. Bhutto used to say. The noise of the democracy is the most essential element of a democracy. So this has been the subject of debate. But your lordship has seen the entire history of how phase by phase this has been narrowed down. The divide has been narrowed. More and more subjects were added. More and more alignment was brought about. Because, my lord, the historical perspective of 370 is very important. The troubled relations. While there's always was a hope that the relations with the neighboring country would be on good terms, the history of Kashmir did give rise to apprehensions. And the lordship has seen all the material. So border state, with all its sensitivities, is what compelled finally the Constituent Assembly to agree to the special arrangement. But with their wisdom, they said, while you phase 18, you have the power to pull the plug. And this is what I call the contextual interpretation. So the plain language, pure text, and the context.
What is the context, Mr. Salve? How is it distinct from the
Yes.
historical background or the plain text?
The context is that this read by itself, forget the history, this read by itself shows that in sub-article 1, there is a divide in the legislative list base aligned to not the constitutional general 7 schedule, but to an instrument of accession. Broadly, the idea was aligned with the instrument of accession. That's how the powers will be shared. And a partial application of the Constitution of India, not in its entirety, but such other provisions. That's the D. That's the context. With a safety valve in 3. And my lord, the history of this provision also tells us it may be in these areas. I'll give your lordship the exact passage. The fact that the ground realities would change in Jammu and Kashmir and 370 would accommodate was not first recognized by your lordship in the Makbul Damnu case, which has been cited. The challenge brought where Mr. Garg argued.
Mr. Salve, which is your compilation of it?
Well, I believe it has been given along with my note.
Is it along with the note itself?
Yes. This is not from the 9th edition of Craze. It's called Disregarding the Impossible. Para 8.2.9. It is appended to the note.
What page did you say, Mr. Zari?
Page 37 PDF.
Yes. Disregarding the impossible.
Yes. Yes. There's a slight difference in text from what your lordships approved, and in fact, it's even more instructive. It says one of the ancient maxims of common law is lex non causa ad impossibilia. As Broom's legal maxim puts it, the maxim, or as it is expressed, impotentia excusat legem, must be understood in the qualified sense that impotentia excuses where there is a necessary or invincible disability to perform the mandatory part of law or forbear. It is akin to the maxim of the Roman law, nemo tenetur ad impossibilia, which derived from common sense and natural equity, has been adopted and applied by the law of England under various and dissimilar circumstances. The result of the application of the maxim, which remains potent, is that the draftsman need not expressly excuse that compliance, which is obviously impossible. So, for example, if requiring a particular communication to take the prescribed form, the draftsman need not generally state that the requirement can be lawfully ignored where no form has been prescribed for that purpose. There may be occasions, however, where the sense of the legislation makes it arguable that the primary provisions are not to operate at all until certain mechanisms have been put to place by subordinate legislation. If the draftsman thinks it is necessary to avoid a suggestion of that kind, he will generally qualify a reference to the prescription by, if any, of that kind. So, my lord, the principle is very interesting. In fact, we have used it in a different branch, my lord. In service law, for example, we've used it all the time. It says your promotion will be as per rules. Now, if no rules are framed, doesn't mean you won't get a promotion. Then you follow whatever is the general principle. But if there are rules, they must be strictly followed. Oh, my lord, this was the argument in this court. Of course, I went through the judgment. It didn't get to that point of deciding it. The old section 80J, rule 19(1)J, and the argument was, for example, if it says deduction of capital employed, if there are rules, you follow them. If there are no rules, doesn't mean the exemption fails. But there are other provisions which says you will get such other deductions as rules may provide. And that you can't operate unless there are rules. So we have had, my lord, these two formats. And that is why we come back to why did the framers of the Constitution not say that if the president receives a recommendation from the Constituent Assembly, then he may. And instead say the president may abrogate this article, provided if he gets a recommendation from the Constituent Assembly, which there is one, you must get the recommendation, otherwise. Now, my lord, this was also made.
Just 1 minute.
I'm sorry.
Mr. Salve? I think perhaps we'll just wait for a second, Mr. Yes, Mr. Salve. Mr. Salve? Voice is perhaps, for a moment he was...
Now, my lord.
Yes, Mr. Salve.
Yes. Can your lordship hear me, my lord?
Yes, we can hear you now.
Yes. Finally, my lord, look at one important nuance of this article.
Yes.
In subclause D of clause B, such of the other provisions of this constitution shall apply in relation to that state, subject to such exceptions and modifications as the present by orders. So, power to the president to apply or disapply provisions of the constitution or apply them with modifications. And this does not require unlike B1, that is the spread in the list, concurrence is not called for.
Let's look at it now, Mr. Salve. Let's see that again. I don't...
Yes. If your lordship sees 370(2)(1)(b), 1 is the spread, my lord, of the list. Small subclauses 1 and 2.
Corresponding to the IOA.
Yes.
That requires consultation.
That requires concurrence. That comes in through the first proviso.
B.
Proviso, no such order which relates to...
requires concurrence.
Yeah, B1 requires concurrence, consultation.
No, consultation.
Correct, my lord? And no such order which relates to matter other than those referred shall be in the concurrence of the court. So this was built in. This dichotomy was built in there itself. Now, two things, my lord, your lordship will note. Applying or disapplying provisions of the constitution.
No, Mr. Salve, I could not get this argument.
Yeah, yes. May I just restate the point, ma'am? Clause D relates to not 370, but other provisions of the constitution.
Absolutely.
And they can be applied, disapplied, or with such modifications as the president considers appropriate. And that is with the concurrence of that government.
Yes.
Correct, madam? And sub-article 2 says, is the concurrence referred to in paragraph 2 of B of clause 1, such other matters, or in the second proviso, that is, my lord, would be D, be given before the Constituent Assembly for framing of the Constitution, it will be placed before the Assembly for such decision as it may take thereon. So this was meant to operate much beyond the Constituent Assembly also, because that concurrence would continue forever. There would always be a state government. But state government, what that state government is another matter. There would always be a state government. But disapplying 370 was carved out and put in 3. Now that can't be a provision limited in time to the existence of the Constituent Assembly. And that is what explains perhaps why the recommendation rather than concurrence.
Mr. Salve, your voice was cracking just a little bit, when you were making this, the last part of your argument.
Yes.
Maybe...
I'll repeat it, Marat.
Yeah, if you could...
Disapplying 370 itself comes under sub-article 3.
Right.
And that is why perhaps the framers of the Constitution scaled it down to recommendation instead of concurrence. And that to put it in a proviso that when there is a Constituent Assembly, during the life of the Constituent Assembly, if you decide to modify 370 or disapply 370, because the whole purpose of the Constituent Assembly was to work to try and find this area of accommodating both.
That's
So if
fair enough. Mr. Salve, we got your point.
Yeah,
That
that's
after all, this is a proviso.
Yes,
It uses the word recommendation and it does
Yes.
say if there is a recommendation. We got that
Yes.
point. We got that line of argument.
I was just closing it by saying,
But you're making just a little while ago
yes,
was that you began by saying that B1
yes,
requires consultation. Matters in the list other than those covered by the IOA requires concurrence. That is B2. Then we went to D.
yes,
D says, subject to such exceptions and modifications as the president may order by order specify.
yes,
There also there is a bifurcation.
yes,
Matters which refer to the instrument of accession require consultation. Other matters other than those governed by the instrument of accession require concurrence.
correct. Now, the point which I was making, perhaps
That's
that
the
got
point which
lost.
we wanted you to just come back
Yes.
again. Yes.
So again, my lord, why this subtlety of instrument of accession being consultation and other than instrument of accession being concurrence, the significance should not be missed. Where it comes to instruments of accession and terms of accession, the last word is with the union.
No, where do you say that? How do you say that?
Because, my lord, instrument of accession requires consultation, not concurrence. The first proviso.
Subjects are so important. Convenience.
Why this dichotomy in the first and second proviso, my lord? Your lordship would have to reflect over. And that also, my lord, feeds into my point, therefore, that where it comes to disapplying the 370 completely, because the whole idea of 370 was accommodating the political compromise in the accession.
You know, Mr. Salve,
Yes,
clause B of 371B
yes,
does not relate to the power to make adaptations, modifications, or exceptions at all.
yes,
What 371B says is that of all the items in the three lists, the president, the power of parliament to make laws would be limited by specific matters.
yes,
So you take the matters in the list as they are, and then you define what would be the domain of parliament to make the law. There's no power to make exceptions or modifications in clause B at all.
no,
And
not at all.
bifurcate, you correctly said that there was a bifurcation. Matters which are referable to the instrument of accession are those on which you only require consultation, because
Yes.
these matters clearly specified in the IOA: defense,
Correct.
foreign affairs, communication. Therefore, when Parliament specified the matters on which it would make laws, if those matters were referred to in the IOA, only consultation with the state government was required,
Yes,
because they were specified in black and white in the IOA.
correct. But
Matters which were not specified in the IOA but are governed by the three lists, concurrence is required.
and my lord,
Now, when it comes to
sorry, yes.
D, D is not just specification of matters. D is making exceptions or modifications.
That's right.
There again, they had a dichotomy. You can make exceptions or modifications, but if it relates to matters in the IOA,
Consultation.
only consultation. So you are really right that insofar as D is concerned, in regard to matters which are specified in the IOA, only consultation is required.
And my lord, one cannot miss the significance. What I wanted to add of the overlay of the principle of international law, which is engrafted in 363. That these are matters primarily for the sovereign. Instruments of accession and their interpretation has always been a matter for the sovereign. And here the accession being complete, irrevocable and irreversible. That is clear. 1 and 3, Article 1 and 3. Where it touched the instrument of accession, the president had the last word. And that philosophy is reflected in sub-article. That if you want to completely disapply this political arrangement, if there is a Constituent Assembly, consult them, otherwise you can do it. And there also recommendation.
In other words, Mr. Salve, what you're trying to drive at is that clause 3 of Article 370
Yes.
is absolutely on the same is on the same
Philosophy.
trend, or is the
Same.
same platform
Yes.
as clause B1 and the first proviso to D. You're trying to equate the power and the substantive part of clause 3.
The underpinning is the same, my lord.
Power
The
under
underpinning is the same.
the first proviso to D and B1.
Yes. And because the underpinning is, this is where we accommodated, or this is where the powers that be, when framing the Constitution, accommodated the political compromise in Kashmir. And unsurprisingly, they reserved the power in the president instead of driving on to Article 368. They reserved the power in the president to disapply this entire. It's a very unusual provision, my lord. There is no other equivalent. The executive president is executive government, where the executive government can disapply a provision of the Constitution.
The only internal problem with that argument, Mr. Salve, we'll reflect on
Yes.
it doing the research in the
Yes.
next hour,
Yes.
that where the power to do something lesser in terms of constitutional impact is hedged in with restrictions, namely the power to make exceptions and modifications. Can we subsume that the power to have something greater, which has
Yes.
greater constitutional impact, namely the abrogation itself, will be bereft of all limitations?
My lord, to which my respectful response is, there is a compromise. I keep in my control, because the accession is complete. So what are the understanding? It's a part of India. 1 and 3 apply. It's an Indian state. But I have a political compromise in which sub-article 1 has how it will operate. That's the compromise. But sub-article 3 is to put the compromise to an end. And I reserve that power.
Mrs. Harvey, we are almost at the anvil of lunch. Just
Yes.
one, maybe one of the juniors can do it here in the court as well.
Yes.
Found which were those matters governed by B1 and which were the matters governed by B2. B1 basically covered the 3 subjects.
Yes.
Which were the matters in the IOA to which the first proviso to D applies?
We'll not try and respond to that at 2 p.m.
So we'll
I see that. I see that.
That will give us some insight on what was the intent.
Yes,
of-
yes. I'm deeply obliged. We'll do that.
So many articles that deal with defense, which are covered by the instrument of accession.
Yes, my lord,
That list is given.
Lord, I had in my list of dates, Lordships would recall, the sub-article A1 says that the president would demarcate which entries fall within those three areas. So there was a specific order passed, possibly the first
It was
order.
48 or 54.
Yes, my lord, which 50, my lord,
50, 50,
50.
50.
which
54
because
then.
communication would have telecommunication, postal communication, etc., etc. So three
So
entries.
which were the other articles?
No, we'll respond to that too.
Because the first proviso to D for Delhi, deals with other articles, not the specification of matters in the list. Not D1. The first proviso to clause D deals with other matters which are governed by the instrument of accession, where again consultation only is required. We're just sort of understanding Mr. Salve's
Communications is also in the list. That is also not other
No,
articles.
I don't think Mr. Sibal has understood. My lord, I followed your lordship's
Also in the
question.
list.
I'll respond to it too.
We'll also try.
That may have some bearing, Mr. Salve.
Yes, of course.
Your argument on clause 3, that's why.
Yes, my lord. Yes, I'll do it at 2. I'll do it at
A
2.
very interesting point. We'll also leave it here.
Yes.
The list is all there. Which one is also in the list?
Stay. Stay.
Yes, Mr. Salve.
Yes, my lord. In fact, I'm grateful to my lord, the Chief Justice, for the steer. If your lordship sees the instrument of accession,
Yes.
and this is in document 1, volume 1, sorry, page 9. Your lordships have it?
Yes. Just one second.
Yes. My lord, Justice Suryakanth has it. If your lordship sees, it's very interesting.
Page 1. Sorry, page 1.
Clause 1 is the accession.
Yes.
He says, I hereby declare I accede to the dominion with the intent of the Governor General of India. So, shall by virtue of this, my instrument of accession, but subject to the terms and for the purpose of dominion, exercise such functions as may be vested by them in the Government of India Act as in the Dominion of India on the 15th day of August. I hereby assume the obligation of ensuring that due effect is given to the provisions, etc. Now look at 3, Mama. I accept the matters specified in the schedule as the matters with respect to which the Dominion legislature may make law for this state.
So this is B1.
Yes.
This corresponds to clause B1.
Yes, my lord. And this was in a schedule which I'll show your lordships in a moment. I hereby declare that I accede to the Dominion of India on the assurance that if an agreement is made between the Governor General and the ruler of the state, whereby any functions in relation to the administration of this state of any law of the Dominion legislature shall be exercised by the ruler of the state, then such agreement shall be construed and have effect accordingly. Now, my lord, comes the most important thing. In 6 says, nothing in the instrument will impart dominion to make any law authorizing compulsory acquisition. Now, this is interesting. This is a carve out from the legislative list principle. But I hereby undertake that should the dominion apply, etc. Now, my lord, 7 is important. Nothing in the instrument shall be deemed to commit in any way to the acceptance of any future constitution or fetter my discretion. And nothing in the instrument affects the continuance of my sovereignty and over the state, save as provided under the instrument. Now, this was the instrument of accession, but the Constitution finally, if the lordship now matches this with 3.7, and I'm sorry, my lord, for completeness, the schedule your lordship will find in volume 4, page 176.
So basically defense, external affairs and communications.
Correct. Now, my lord, what happened? But what the spread in 370 corresponds to? is very important. 370 starts by saying the Part B provision will not apply. 238 will not.
Right.
Then it says the power of Parliament to make laws shall be limited to those matters in the Union and the concurrent list which in the consultation with the government of the state are declared by the President to correspond to matters specified in the instrument of accession. So this was on the issue of the legislative lists and that schedule. Matching them with our 7th schedule, and the President would decide how the 7th schedule is to be divided. And here it's only consultation consistent with the philosophy that accession and instruments of accession, these are what are in international law called political documents, not political in the political sense. Political
I think, Mr. Sarve, it's very clear now. If the President wanted to make any exceptions or modifications,
yes,
in respect of defense, communication, or external affairs, then only consultation was required.
correct. Now,
That is
my lord,
of the first proviso to clause D.
correct. Now, my lord, applying other provisions of the Constitution, and my lord, I don't have to give your lordships a catalogue of which are the other provisions. I mean, there are so many important provisions of the Constitution. They would be phased in and applied under D.
Right.
And for that, they said concurrence.
They would require concurrence.
They would require
Yes.
concurrence.
They referred to either defense,
Correct.
the
But the
defense,
legislative
external
lists,
affairs or communications.
broadly, let us say the legislative lists are put to one side because that is really power to make laws.
Yes.
But for institutions, your lordship's jurisdiction under 32, for example,
The Constitution also, yes.
your lordship's jurisdiction under 32, should it extend or should it not extend to Jammu and Kashmir? These are, and what about public service commissions? What about election commission? So on and so forth. So not all those were provisions to be applied if necessary with adaptation. Now, not what is important, and I come back therefore to my point. This, how does this align with a complete accession? Article 3 is the answer. That this is an arrangement for the phased introduction of the Constitution, keeping or reserving unto the President the power to disapply this article. Now, obviously, for that, there cannot be concurrence. So it makes sense. Recommendation if there is a Constituent Assembly, otherwise, the action of the President. This was the arrangement, this was the compromise. And my lord, this compromise was not just with the state of Jammu and Kashmir. The solicitor has placed before your lordships the sharp differences of view even in the Congress Working Committee. They rejected this plan. First time when Shri Gopal Ayangar presented it. Sardar Patel's letter is cited in the solicitor's list of dates. And he said, sorry, I don't accept these. So there were, this was a very matter with more than one point of view and competing points of view. So this was the compromise formula, which is incorporated here in the Constitution. This was the workable arrangement. This is all right. Ultimately, we will decide and we will keep to ourselves the power to disapply this article. But if this works phase by phase, introduction of the Constitution, why not? And it did work to a large extent. So one of that principle, which my lord the Chief Justice was pleased to put to me, about lesser power and larger power, would it not require greater safeguard? That would not occur. That's what I call the contextual argument. I'm not finished with this, and I have eye on the clock. If
Yes,
there's anything
sir.
more, I can assist your lordship on this point. Otherwise, let me move to my next
We
point.
can move, I think we can move to your next point, Mr. Salve.
Yes, yes. Second point is, my lord, there has been some arguments about even if 370 applies, no radical change. And Delhi laws was citing. Now, my lord, some cleaning up, because some principles need to be clearly stated. The Birla cotton mills in Delhi laws, the power to extend laws, you cannot make a radical change. But that can have no application here. That principle can have no application here. Because your lordship has seen those cases. Your lordships read down the power to extend and apply laws under Article 14. The argument was excessive delegation. You have conferred upon the executive the power to change a law made by Parliament and its application. And that is why your lordship said we read it down. That the philosophy, the basic policy of the law cannot be changed, radical changes cannot be made. My lord, 370 is a part of the Constitution itself. There is no question of excessive delegation. This is a power conferred on the president. And that is why my lord Lakhanpal rejects this approach. But I was giving your lordships an answer on first principles.
Yes.
The power, my lord, under 370 is plenary in nature. And this is a power conferred by the Constitution. A plenary power is not subject to the principle of, or is not amenable to a challenge of excessive delegation because the Constitution has made this delegation. Where Parliament makes a law which is subject to Article 13, or where the state legislature makes a law which is subject to Article 13, then an Article 14 challenge can be brought saying this is excessive delegation. And all the Delhi laws, in Delhi laws downwards cases, all dealt with excessive delegation. In statutory provisions on the anvil of Article 14, is completely irrelevant to 370. Your lordship has already said this in Puranmal, but I wanted to just put it on first principles.
Yes.
The second, my lord, point is that the power exercise is legislative in character. I don't think I need to belabor that point very hard. Applying provisions and disapplying provisions, modifying provisions of a law is legislative in character. I don't think I need to cite authority for that matter. To suggest that this is an executive power is like saying ordinance making is executive power. And it is done by orders, Malad. I'll just give you a lordship a citation. The Meghalaya case with Schedule 5, for example, of the Constitution. 1972, one Supreme Court case is 148, just for reference. where your lordships have said that, because there also the president can by order say this and by order say that. You're not saying. So this is now what follows from a plenary power and a power which is legislative in character. It has a direct bearing on the next issue of the extent of judicial review, of the exercise of that power. Because that logically takes me to my next point, that the Ajit Mills principle, as Justice Krishna has explained in Ajit Mills. In the context of a law made by Parliament, if you say this is abuse of power or colonial legislation, it's an argument of competence, not of motive. That is one of the Ajit Mills principle. Your Lordship knows when the first law was made, saying if you've collected illegal sales tax, which is not chargeable, if you've collected, you pay. The argument was this is tolerable legislation because you're taking away. And Justice Krishna's answer, I'll just give the page and para numbers, 77 4 SCC, page 98. This is attached to my note. This is attached to my note starting from page 6, page 4, sorry. And the relevant paras.
But Mr. Salve, even if it is a legislative power,
Yes.
as you say it is, and probably it is, it's amenable to judicial review on the ground of Article 14. A legislative power cannot be challenged on the ground of mala fides. For instance, you cannot say that Parliament did something because of a mala fide intent, because you don't attribute mala fides to a collective body of individuals. That's the reason for
That's correct. More than that.
Nagaraj, when they reduced the age of retirement, our court said you can't challenge the reduction in the age of retirement on the grounds that Parliament was acting mala fide, because it's a collective body. Mala fide is something which you attribute to an individual.
More than that, my lord, your lordships have always said, where it comes to colorable device, supplementary, and all these, as it is not explained in this judgment,
actually they started that.
It is really a competence argument.
Colorable exercise of power in Tulloch, our court said, it really means that though you are purporting to exercise power under one entry, you've actually transgressed into another entry. So it's really a question of absence of power, legislative.
It's a competence argument.
It's a competence argument.
Yes. And it's not the Wednesbury unreasonableness.
Yeah. But equally, Article 14 would be attractive.
But 14
meet the test of Article 14.
But 14 can have no application to an Article 370 sub-Article 3 situation. Of course, legislative power you can, if you make a rule which is plainly discriminatory, you can strike it down on violating 14. Of course. Because if Article 13 applies, the whole panoply of fundamental rights apply.
But therefore, assuming that this is a legislative power, it is not immune to challenge on the ground of violation of fundamental rights.
Correct. Fundamental rights, whether a 370 sub-Article 3 disapplying Article 370 is at all amenable to fundamental rights, question mark. I'll address your lordship for a minute on that. Because this is a relationship between the union and a unit of that union. We are now units of that union.
They may be parts of that relationship which create rights in favor of individual citizens.
But if it affects an individual,
a classical part of that, the provision of the on the right of residence. And an individual, for instance, can say that I and people belong to my class have the exclusive right of residence in this state. By bringing in others, you are affecting my right under Article 14. Whether there's substance or not is a different thing altogether. But it's amenable to that challenge. You can't say that the challenge is immune.
My lord, I would respectfully submit applying or disapplying the constitutional provision would not give a individual citizen a right, because I'll tell your lordship, this takes us back to the basic principle of this is adjusting the accession. Now, my lord, in international law, for example, a citizen can never assert that I had certain rights under an earlier legal regime, and now there is an accession, those rights should be continued. Your lordships have rejected that, consistent following the principle of international law. You have only such rights as are available to you within the territory. Now, in that, if there is a discrimination, you can challenge. Today, my lord, which constitutional regime will apply in Jammu and Kashmir is more, in one sense, almost a constituent power. So, my lord, Article 14 challenge on the ground that I was a citizen, I was living in Kashmir, nobody else was allowed to enter here, now you've taken away my rights. That argument will not be open.
That's quite apart from, of course, the submission of the solicitor that by the abrogation, you expanded the panoply of rights which are individual, which an individual in Jammu and Kashmir has. You have
No,
not
I'm not taking an extreme case. Can an individual come and say, I had a right to live here, splendid isolation? You've taken away that right, and now all Indians have the rights, which I earlier had as a special right.
Your contention is that the residents' right to live in Jammu and Kashmir is not taken away.
Nothing. Their rights are expanded by applying the whole of the Indian Constitution. Nobody has a vested right in a state of governance in that sense. And Malad 370 is a part of the Constitution where the president has a power to disapply the Constitution. If he disapplies the Constitution, how can a citizen complain? A resident of that state. As much as a resident of outside Kashmir could not say, why am I made subject to parliamentary legislation when this subject in the state of Jammu and Kashmir is not? And in fact, Malad, we used to always, I remember the late Altaf Ahmad used to always have a little joke. He says, you people have lost the right to property, we haven't. 19-1F continued, the equivalent continued under the Jammu and Kashmir constitution. We got rid of property rights. Now, could an Indian complain, could a person outside Kashmir, a fellow Indian, say that my fellow Indian there in Jammu and Kashmir has a right to property? If you take his property, you have to pay him full compensation. But if I am outside Jammu and Kashmir, take my property and you can show me a blank piece of paper and there's nothing I can do.
370 now leads to the abrogation of 19-1F in Jammu and Kashmir.
It does.
But which is not a part of the basic structure. 19-1F has been held not to be
It is not as much today. If you are creating a larger equality, the solicitor has developed this point, you created a larger equality. Where is the question of violating 14? And individuals, Malad, that principle must be extended. Your lordships have dealt with this problem, where the argument was there were prior leases. Your lordship said, sorry, post-accession, you have what the law gives you. You have nothing else. Now, if post-accession...
Actually, we need not really explore this line much for the reason that this might have impacts on other parts of the Constitution.
That's why, Manoj, I was...
The Constitution which creates rights in favor of specific groups.
Yeah, Manoj, that is why I limited myself.
Whether they're based on religion, whether they're based on caste, on marginalization. So to say that by obliterating that right, you're not affected by a larger equality, maybe?
My lord, 370 operates.
Argument if we accept it in that broad
No,
sweep.
no, my lord, that is why I'm saying
Getting to this,
370.
because I don't know what the ramifications.
No, no, my lord, 370 operates in a very narrow area. Very narrow area. It operates in the context of the compromise formula put in place for Jammu and Kashmir at the time of accession and at the time of its integration into India, etc., etc. And this power was kept to disapply this one provision, this special arrangement. Now, my lord, there is no equivalent in the Constitution. So we needn't go, my lord, the Chief Justice is saying, the danger in getting into constitutional propositions in one context and making broader observations, my lord, we don't know what you are trampling underfoot for the future. My limited submission was the principle of limiting delegation by statute, which comes from Article 14, can't apply. This radical change is a reading down of the power to extend laws.
That point you've made, Mr. Salve.
That's the only point which I was making. The second point I was making was
restricted to that level. There is no difficulty.
That's all. And the second point which I was making was, my lord, that here abuse of power is really a power of competence.
And nobody's challenged the provision of clause 3 of Article 370. That is
which, my lord, in fact brings me
part of the original constitution.
In fact, my lord, which brings me to my next point, and I'm going quickly now because your lordship has seen the point. That this repeated reference to basic structure, my lord, quite frankly, even in some of your lordship's judgments, I find a little surprising. Basic structure was not a principle as an independent standalone constitutional right. Basic structure is the limitation inherent in 368. And constitutional amendments are tested with reference to the basic structure of doctrine. Well, there are some judgments which do say this law not only violates 14 but violates the basic structure. Laws, strictly speaking, if you
laws don't violate the basic structure.
Laws can't violate basic structure. Laws violate part 3 or don't violate part 3.
You know, in 2 judgments, though, we have said that a particular law protects the basic structure. One.
But laws are aligned with the basic structure.
Places of Worship Act in Ayodhya, we said that is in pursuance of the.
Correct. But laws.
The second, we said that the amendment to the introduction of the amendment for Delhi in 239 AA was in furtherance of the basic structure, which is.
Furtherance of basic structure.
So there's a little bit of.
No, but let me try and, in my very humble submission, when a law is made to protect civil liberties, 21 is a part of basic structure. A law made to protect civil liberties is a law aligned with Article 21 and therefore aligned with the basic structure. Now, one may in a flourish of language say it is to further. Today, if there are checks and safeguards built into arrest, checks and safeguards built into criminal trials, etc., etc., you may say this is to protect the basic structure, because the basic structure is the trilogy of rights. Now, that is not to say that the law was tested on basic structure.
That distinction you've made. Yes, of course, because as a doctrine, it was evolved to test the validity of constitutional amendment.
The problem is, one thing is to say something is aligned or not aligned with the basic structure. But to say that an exercise of power under 370 can be tested on the basic structure doctrine, I submit is a misconception. 370 itself is a part of the original prestige constitution. And that confers the power to disapply the constitution, the arrangement. If I am right on competence,
Anything else, Mr. Sarve now?
So, my lord, that is the basic structure point.
Yes.
And the point which we have therefore already made, and I close with that submission, how would your lordship interpret this? The nature of the provision is such, if it confers plenary powers, not in the field of civil rights, not in the field protected by Part 3, but in the area of governance and in the area of constitutional adjustments, your lordship will give it the widest possible. Because the idea is never to hedge in future generations by reading the constitution narrowly. My lord, that is a well settled principle. Last point which I have to make, my lord, is if we are wrong on this, the 356 test. Can a change of permanence be made when a 356 regime is in place? It has two answers. I'll just take 2 minutes on this. This is no longer res integra. Your lordships have right from Rajasthan and Union of India, Bomai, chiseled this law and said, up to the stage where Parliament approves, don't do anything which is irreversible. Thereafter, you may. Because everything in one sense is irreversible. What Parliament does is also irreversible. Parliament passes the budget for the states. It takes over the coffers of the state. What money is spent is irreversible. The money is gone. But that's the way it is. The president may not dismiss people, appoint people, create institutions, remove institutions. The governor may do, the president may do under 356. Those are for those people irreversible actions. That is why your lordship has said 356 is draconian and should be very sparingly used. If the unfortunate circumstances require that for a defined period of time, the system of governance is changed under 356. If those unfortunate circumstances exist, and a very narrow area of judicial review is permissible, it doesn't arise because there is no challenge before your lordship, a bald prayer without the necessary averments, the challenge. Then, my lord, one is to accept the consequences of 356. But that's in the alternative. If I'm right on my construction, my lord, of the proviso, quite frankly, minus the Constituent Assembly, it fell away. So you just added the state legislature and then you acted for the state legislature. Nothing my lord, dramatic really happened. If one ignores that also, if we are right on the proviso, then none of those questions arise. That, my lord, is the submission, unless there's something else I could assist your lordship.
Thank you, Mr. Sarve. That would be all. Thank you, Mr. Sarve.
Much obliged.
Yes, Mr. Dev.
With the leave of my learned friends, I'll try to be as possible to conclude my submission. I don't want to eat into their time too. A couple of things, your lordships will notice in my written submissions, page 41. I have the lordship's leave. I have a 2-page note.
Yes, certainly. You can give
Which
us
I
that.
have forwarded to the master. It's like a summary of my submission. No, it's been given to the.
You just upload. Yeah.
Before I just, it's let me open before that. The three broad reflections I want to share with the court.
It's what you call opening out.
Yeah, but before I read that, Lords will just make a note of three broad reflections. What they are. One is the history of president rule in J&K. In that regard, I have my submissions at page 41 of my written submissions. You'll just make a note of that. So three broad points I would like to place before your Lordship. One is the history, then on the scope of 356, and then sovereignty, and finally on binding upon 370. So on these three aspects, I request the Lord just make a note of the relevant pages in my written submission. At page 41, just briefly sketch the history of president rule in J&K. And Lord will make a quick note of paragraph 2 of this under this heading. So I say there is no constitutional injunction barred that during the imposition of the president rule under Article 356, any measure under Article 370 cannot be undertaken. So I say they can be undertaken. So the following orders which are spelled out in the paragraph 2 are examples of such exercise or measures. And thereafter, let's just make a note of 2 or 3 paragraphs here. Paragraph 5, paragraph 6, and then paragraph 7. May just read paragraph 7. This is at page 42, my written note. 66. Because as I try to point out in the footnote that the canvas which needs to be addressed is of such complicated issue that it only put in a straitjacket. So I see in paragraph 7, well, all political choices or political action may not be free from the scan of judicial review. This would be a qualified statement. The combination or choice of measures to be undertaken by reason of the duty imposed under Article 355 and the authority always available in the Article 3 of the Constitution of India will all be matters of a class of decision making and deliberation which will deserve deference and not scrutiny. May I qualify being and not strict scrutiny, if I put it like that. Then also kindly make a note of paragraphs 9 and 10 in the same sequence. Particularly paragraph 10. Page 43. And that follows that extract from Bommai, very carefully worded provisions about the political ticket and questioning the political wisdom, etc. Following that, paragraphs 9 and 10. I just quickly read them. S.R. Bommai principles on justiciability of the exercise of power by the president may not be mechanically extended to circumstances of imposition of president's rule in the context of matters such as external aggression and internal disturbance, and more particularly in the context of the dynamics in relation to the border states. In paragraph 10, consequently, CO 272, which can be treated as a product of consolidated stock taking of decades of internal disturbance, and unrest in the state of J&K is a valid exercise of power by the president to achieve a larger constitutional and public interest aim. That's how that aspect ends. Then, on scope of 356, kindly turn over to page 47 of the written note. I'll just quickly take your lordship through a few paragraphs. Well, in paragraph 1, I talk about the preamble, and paragraph 3.
Yes.
Um, And then thereafter, in paragraph 4, I'll quickly read that. On a plain reading of Article 356, it is obvious that the makers of the Constitution deemed it fit to give a very wide and extraordinary powers to the President in Article 356. Such power the President can exercise either in the receipt of a report from the governor of state or even otherwise, on being satisfied that a situation that is in which the government of the state cannot be carried on in accordance with the provisions of the Constitution, the President may proclaim any or all of the following. So having regard to the amplitude of the powers, then kindly turn to paragraph 5. That's why in Badrinath, we'll also just make a note of the judgment that's available in volume.
Badrinath was cited by the
That's
solicitor.
right.
Yes.
Just paragraphs 25 and 26 of Badrinath.
Yes.
So kindly make a note of those two submissions in paragraphs 5 and 6 here. Also, please make a note of paragraph 8, where we have set out how proviso to Article 3 has been suspended during presidential proclamation, Article 356. In the following case, we're given a list of all those cases when therefore it is not something a departure here. It's in tune with the constitutional practice. Sorry, where is it gone?
The other things,
Yeah.
Bommai and Badrinath, we've of course seen the solicitor cited both the
Sure,
judgments.
please.
So
Just make a note of those paragraphs which is spelled out, paras 10,
we've got
13
that,
in this
read
note.
that.
Then I'll quickly run through this. Well, kindly turn to page, please revert back to page 16.
Go back to 16.
Try to talk something about the sovereignty issue, the division, and then you have the thesis that you have retained something with you.
Good.
We'll do is we'll go through the submissions in the evening today.
Your Lordship, please.
If there's some further query, then we can pose it to you in the morning.
Can I just
or
quickly
for two
therefore
minutes.
take your Lordship so that 2-page note we just, then I'll complete.
This one. Yes.
I proceed to read it. Where is it? Okay. Where do you put it? This thing. The process of constitutional integration of J&K bears all the resemblance with the process of constitutional integration of various territories of India, namely democratization combined with the merger of small states, formation of union state, the idea of having constitutional assemblies for framing constitutions, etc. There was no distinct or special compact between Union of India and J&K as far as the constitutional integration process is concerned. The political compulsions which intervened in the case of J&K resulted in the formalization of the process of integration as enacted in Article 370. This formalization of the process has no flavor of a distinct special or a special compact, the object being constitutional integration. May proceed. Then 2, various 3 is about Article 317 on behalf of the petitioner, the self-serving propositions away from the text and context of the provision and the intent and content of the provision. The context, namely the deliberations required for the extension and applications of the provisions of the Constitution of India and J&K to J&K in order to suit its needs and requirement and its ultimate constitutional integration is the object of Article 370. This process is expected to be completed in the course of deliberation by the Constituent Assembly at one level, having regard to all the constitutional orders issued before 1957 and Section 5 of the J&K Constitution. It can be stated the process of integration was complete. At another level, taking stock of the issuance of constitutional orders by the President beyond 1957, the majority of which is in the nature of constitutional updating, it can be stated the updating has been perceived as a continuing link. We open to the President to take a final stock of the exercise authority under Article 371D and to decide as to whether there is a need of updating exercise at all or the need for any other invocation of Article 371D. This power of the President is not limited or conditioned by any practice in relation to Article 370 in the past. All propositions relating to sovereignty, external or internal, divided or shared, are completely inappropriate in the context of J&K. There's no distinction between constitutional integration and assimilation of J&K and the other parts and territories of India which integrate the Union of India. There's no basis for an artificial line drawn between internal and external sovereignty. All statements about federalism are based on political practice. What matters is the arrangement of powers and authorities in regard to the units of the federal structure. Once the arrangement is drawn on the basis of submergence, If any attribute of sovereignty is only the arrangement to be looked into. There can be no room for any subsisting elements or attributes of sovereignty thereafter. Part 18 of the Constitution of India is a composite scheme calling for its flexible application, having regard to the fundamental mandate of securing the integrity and unity of India. The application of provisions of Part 18 in the case of border states and the appreciation of factors to be reckoned in the regard will not be justiciable. It is open to the President and the Parliament to act both under the scheme of Part 18 and the plenary powers under Article 3, which is not conditioned with the provisions of Article 356. No rights in relation to representative democracy have been taken away. Reorganization of states include temporary or other rearrangement rights to serve the integrity of federalism and the unity and integrity of the country. All rights are available for exercise only if the unity and integrity are intact. The doctrine of necessity is flexible. The long history of internal disturbance, lack of availability of real measures of rights and justice are matters that can be legitimately taken into account for paving the path for due course rearrangements. No person can have a vested right in favor of a perennial state of unrest, and all instruments of law which have not subserved peace